Thank you, Jeff. I can't sit down when I do these things, and I feel bad for you all sitting down at 4:30 today. So at least I'll be standing up, and you can vicariously stand up during my talk if that's helpful. Jeff has really sort of introduced or provided a lot of the background on the project that we've been working on consumer arbitration. That yes, there's a sort of important ongoing policy debate in Washington and elsewhere over the enforceability of pre-dispute clauses in consumer contracts as well as employment and franchise contracts. And what we have been looking at in particular is consumer arbitration, so that's what I'm going to be focusing on. There's been another sort of variety of other interests, some state legislative interests, although the Federal Arbitration Act limits what state legislatures can do in addressing or looking at consumer arbitration clauses. And then in the judicial forum, obviously, many of you, I'm sure, are at least certainly aware of the application of unconscionability doctrine to police, to some extent, unfairness in consumer arbitration clauses. So it's basically been widespread interest in the issue. A lot of the times the interest has been, or the sort of discussions have focused on anecdotes, right? Individual cases, something goes bad in a particular arbitration, or whether something goes bad in a particular arbitration clause. And what this project brings to the table, and what increasingly I think, at least on Capitol Hill, people have been interested in, is not just the anecdotes, but broader sort of data on what actually happens in arbitration proceedings. I've got a quote from Professor Bo Rutledge at Georgia, which from my perspective, I like the sentiment. I think it's a little over-optimistic, suggesting that there's now this consensus that the future of arbitration should be decided through data rather than anecdote. I think that's probably a little too strong, but it sort of is the goal or what we're hoping to assist in with this research project, is provide data on what goes on in arbitration rather than simply looking at individual stories. And the reason that's so hard to do, frankly, as you all probably have a sense, is arbitration proceedings themselves are secret. This is not like a court proceeding where you can just go sit down or go walk in on and watch an arbitration proceeding. These are confidential proceedings, and so the data is generally not available. Now, that said, we sort of a little bit of discussion, or I guess there was a question in the last panel about the accessibility of online court data. Yes, court proceedings are public proceedings. Having spent most of my summer trying to find information out about court proceedings, even though they are public, it can be hard to find data on particularly state court proceedings as well, but I'll come back to that. But our goal here was to look at one arbitration provider, the American Arbitration Association, which is perhaps the best known arbitration provider in the United States, and look at how it administers consumer arbitration cases. It's got a fairly extensive caseload, and we've spent, Sam Zients, who's a research associate at the Searle Civil Justice Institute, and I spent a couple weeks in Philadelphia being junior associates and looking through boxes on cases and collecting data from those cases. And we've issued 2 reports so far. Jeff alluded to one, which was issued in March. There are hard copies available outside the room for those of you who are interested who haven't already seen them. And then an interim report, sort of shorter, not quite so elaborate report issued just about a month ago. And I'll talk briefly about both of those reports and give you some idea what we've been finding. Now, again, our focus here has been on consumer arbitration administered by the American Arbitration Association. Right, there's a lot of providers, some of which have gotten a lot of bad publicity this summer in particular, that have also administered consumer arbitration cases. And we're very careful, and we don't claim that sort of this is the only way consumer arbitration works. But as a matter of policy, too much of the debate, I think, has focused on extreme cases or sort of bad actors. And it's worth looking more broadly, I think, and seeing what other companies, or not companies, because the AAA is nonprofit, other institutions, arbitration providers, what they do and seeing how it works. So there's basically 2 different things we looked at with our preliminary report. The first is just some basic descriptive data about what happens. So how long the cases take, how much they cost to the parties, how much the parties essentially have to pay to the AAA, and what happens in the cases. And then we also looked at the AAA's administration of some private fairness standards it has developed in those cases. So just to give you some idea or some illustrations of what we've looked at or what we found, this is just basic data on what happens in consumer arbitrations that the AAA administered, the cases that we looked at. And essentially what we found is consumers won roughly 53, 54% of the time in the cases that they brought, and businesses won roughly 83% of the time in the cases that they brought. Okay, and it's been really interesting seeing the reaction to these numbers because basically both sides in the debate, the sort of pro-arbitration side, likes the numbers because I guess 50% sounds like a good high number as far as how well consumers prevail. And the consumer groups, the sort of anti-arbitration forces, seem to like the numbers because, look, businesses win 80% plus of the cases they bring, and consumers win 50% plus of the cases they bring. And so this shows that arbitration is biased in favor of businesses. Both of those statements are wrong. You can't tell just from looking at what happens in arbitration as to whether arbitration is fair or not, which is sort of precursor to the second phase of the study, the interim report, which we'll come to in just a minute. But just looking at, 50% win rate doesn't really tell you anything, right? Because it's sort of as compared to what? And at the as compared to what piece, it doesn't make sense to compare how consumers do to how, in cases they bring, to how businesses do in cases they bring, unless they're bringing the same kinds of cases. Right? And as we'll see, as we'll talk about later, it turns out that businesses, and I guess this shouldn't be surprising, bring very different kinds of cases than consumers bring. Right? Consumers are bringing cases based on alleged failures of the businesses to perform, but businesses tend to bring debt collection cases. Right? They've got liquidated amounts, and in many of those cases, the only issue is, did the consumer fail to pay, and if so, how much it is. It's not surprising that businesses tend to win a lot. And so neither the sort of absence of a comparison on one side or the comparison between business claims and consumers' claims itself, neither of those are particularly meaningful, which again sort of leads to the further phases of the study I'll talk about in just a second. So this slide's nice, but it doesn't really tell you anything. So never mind. This slide I think is actually, we do some comparisons. There are some things that we could compare, and here what we compared is how repeat players in arbitration, right, repeat businesses, ones who arbitrated more often, did relative to businesses that arbitrated less often. And the theory here, or the criticism of arbitration here, is that repeat players are going to tend to do better. Right? Arbitrators, unlike you folks, only get paid when they get picked to decide a case. Okay? And so the arbitrator wants to make money, and so they want to curry favor with the parties who are more likely to pick them in the future, which is going to be the businesses, and in particular the repeat player businesses. And so the argument is, well, we expect arbitration to be biased in favor of the repeat players. Okay? We did several different tests of several different definitions of what a repeat player is. Some of the definitions basically we found no effect whatsoever of repeat player status on outcome. There was at least one definition of repeat player where we found some effect where, yes, in fact, the repeat players did win more often in arbitration. Okay? But again, that doesn't answer the question. Right? That sort of raises the issue of, well, what does that mean? Because there's an alternative explanation for what happens with repeat players. And that is, well, maybe the repeat players, right, maybe the AT&Ts of the world or the Walmarts of the world have some other advantages over non-repeat players, other than just arbitrators want to curry favor with them. Maybe they have more experience at and are better at screening cases. Right? They can look at a case and they can tell when they're going to lose and they settle the case rather than take it to the arbitrator. And that theory would suggest that it'd give you the same results, right? You'd expect that the repeat players would actually do better because they're settling all the cases they're going to lose, and the ones they're arbitrating tend to be the ones they're more likely to win, so not surprisingly, they tend to win cases more often. So that's also consistent with what we found, which is the top half of the slide. Okay. How do we distinguish between these two explanations, the arbitrator bias explanation and the case screening explanation? Well, one possibility is look and check settlement rates or non-award dispositions. Okay? The case screening explanation would suggest that, well, yeah, the reason repeat players do better is they settle cases that they're expected to lose, and we might expect them to actually settle cases more often, right? To have fewer cases or a lower percentage of cases go to award. Okay? Which is not, that implication I don't think would follow from the bias theory. So what we looked at is how many of these cases are resolved without an award, and sure enough, repeat players tend to resolve a lot more, 71% of the cases that they adjudicate, or that they face, that are brought against them without an award, as opposed to only 50-some% for repeat players, or for non-repeat players. Okay, which supports the idea, and it's consistent with other findings in the literature, that in fact what's going on here is not a bias in favor of repeat players, but is in fact simply reflects the fact that repeat players are better at screening cases. Okay, so no evidence here we're finding of bias in arbitration. Okay, so that's sort of one piece of the first study we did. The other piece was to look at, as I said, private fairness standards that the American Arbitration Association has promulgated, which is, you may have heard, they're sort of called the Consumer Due Process Protocol. Okay, which sets out various standards that, in the AAA's view, and actually this wasn't the AAA's view, this was a committee that the AAA put together, but that involved consumer advocates, business people from the business side, experts on arbitration, and so forth, to define what constituted a fair arbitration proceeding. Okay. And the AAA actually enforces those standards by refusing to handle cases that don't meet the standards. At least that's what it says. Okay. And the criticism it received was, well, yeah, you say that, but we have no way to tell because we can't see what you do, right? Because arbitration is a secret proceeding. So what we did is we examined the AAA standards and examined how it said it was applying them, and then basically audited the cases to see if, in fact, that's what was going on. And what we found was that, in fact, yes, in the vast majority of cases, 98% plus, basically what happens is what's supposed to happen. If there's a problem with the arbitration clause that conflicts with the due process protocol, such as, for example, there's a waiver of punitive damages, the AAA should refuse to handle that case. And in the vast majority of cases, they do. Okay. So another example would be a restriction on where a provision that the arbitration takes place in some place in a location that's inconvenient for the consumer. All right, the AAA should refuse to arbitrate that case, and in the vast majority of cases, that's the result that follows. All right, so as a general matter, the AAA does a pretty good job. Yeah, they screw up in some cases. They could do a better job, but they do a very good job of figuring out and sort of applying the standards that they say that they're applying. Okay. Further evidence, I guess I'd say, of that is, and the AAA doesn't monitor this characteristic, so it's something we had to kind of dig out ourselves. AAA says they're going to refuse to administer cases that don't comply. And in fact, we found in what year it was, in 2007 alone, roughly 130 cases that they refused to administer. Basically, they turned them down, turned the case away, saying the arbitration clause here is not a fair clause, we're not going to handle it. And further, this process itself has more systemic effects because a further step from the AAA, at least what the AAA says it's doing, is it then contacts the business and says, all right, your clause doesn't comply, fix it. Okay. And again, we identified roughly 150 cases here, not just from 1 year, but over the course of the AAA's doing this, where in fact the business had turned around and said, okay, we'll fix the clause going forward. Either we'll waive the provision altogether for future cases, or even better, get rid of the provision in the clause or change the clause itself for future parties. Okay. So certainly not suggesting that this does away with any need for courts to use unconscionability analysis or for Congress to think about possible regulation of consumer arbitration. But on the other hand, you shouldn't ignore the existence of private processes, or policymakers shouldn't ignore the existence of private processes in deciding what to do. Okay, so that's the highlights, I guess I would say, of our first report. The second report, which came out in November, focuses on a much narrower question. And this is the comparison point, right? We sort of have lots of data from the first report about what happens in arbitration. The question then is, how does it compare to other decision makers? In particular, how does it compare to cases in court? Right? That seems to me really what we should be looking at, right? We shouldn't look at what happens in arbitration alone. We shouldn't be comparing business claims to consumer claims in arbitration. What we really want to know is, how does what happens in arbitration compare to what happens in court? Okay? And that's a nice thing to say. Jeff has been asking me for months how to do it. It's easier said than done, but the report we just issued takes at least a stab at part of that question. Okay? And it's fairly narrowly focused in that, the hard part is comparing comparable cases, right? They need to be, it doesn't make sense to compare different cases in different forums because you'd expect different results. So we try to compare comparable cases in the two different forums. And the easiest way, or the sort of most comparable cases we could identify, were business debt collection cases, right? Because they have a lot of the same issues. Is there a debt owed? And how much is it? And did the consumer fail to pay? Okay. And again, even in this setting, there are differences, but at least we have a baseline of comparability. Okay. And here's where I got to spend lots of time on the Oklahoma court webpage, and I congratulate the Oklahoma judges in the audience. I think you have the best webpage online access from a researcher's perspective to case data, because you can actually search for groups of cases rather than just going and finding in individual cases. So we used Oklahoma data. We got a data set from another researcher on Virginia cases. There's some federal court debt collection type cases, basically student loan collection cases. And so we looked at all these cases, and again, the goal being here to give us something to compare the arbitration cases to. Okay, and the reason it's important, and I'm just going to sort of quick flip through these, And I've already said you shouldn't do this, but people are still doing it. Here's a letter that a bunch of academics wrote to Congress in support of the statute, or the proposed legislation on, that would enact or establish a consumer financial protection agency. Okay? And basically what they say is, look, businesses win 80 to 90% of the time in arbitration when they bring cases. That shows that arbitration is biased. Okay? A more colorful way of saying that, this is Elizabeth Warren, who is the, she oversees the TARP funds in addition to being a Harvard professor. Okay? She says arbitration is like the Death Star. Right? The empire always wins, although I think she saw a different movie than I did, but that's another story. The idea being you can tell that arbitration is bad simply by the fact that the business wins all the time. Okay? But what's interesting is when you start looking at what happens in these cases in court, for what it's worth, businesses win at least as much, if not more, in court than they do in arbitration, at least the AAA arbitrations we looked at. All right, so the AAA arbitrations we looked at, businesses won in these debt collection cases sort of 80-some to 90-some% of the time, 86 to 97% of the time. When you look at federal court, student loan collection cases, Oklahoma, small claims and smaller claims cases, Virginia state court cases, the businesses win 98 to 100% of the cases that go to judgment. Okay. Similarly, if you look at the amounts they recover, same thing. Right? I mean, the problem with using win rates is you're treated as a win even if you win $1 rather than sort of the full amount of your claim. Here, when you look at the arbitration numbers, the businesses win in debt collection cases 92 to 99% of what they're asking for. In court, it's 98 to 99%. Very similar numbers. Okay. Now, we certainly don't claim that this shows that arbitration is great for consumers and that consumers actually are better off in arbitration. But at a minimum, I think it dispels this idea that you can tell whether arbitration is fair or biased simply by looking at what happens in arbitration. Because on that standard, courts are worse. Okay? And again, I'm not suggesting that's the case, but to me, it highlights the importance of doing the comparison. And particularly what it suggests to me is really what may be going on here is characteristic, or what's important here is characteristics of these types of cases. Right? That really the sort of common theme is businesses usually win when they try to collect debts, whether they're in arbitration or in court, okay? Rather than arbitration is bad because businesses win all the time when they try to collect debts. It's really the type of the case, I think, rather than necessarily, from what we can see, the form in which it's resolved. Okay? Now, the project's still ongoing. There's lots of limitations that, if you read our report, empirical research papers always have lots of limitations, right? All we're talking about is the American Arbitration Association. There's always hazards in dealing with litigation, cases that are litigated as to cases that are settled and how those affect the outcomes or so forth. Okay. We don't look at consumer claims. That's one of the things we're hoping to be able to turn to in the next phase of the project. Okay. But it's been a great, from my perspective as an arbitration scholar, to actually be able to look at what happens in arbitration has been fabulous. And the fact that other people, for once in my life, are interested in something I'm researching has also been a nice plus. So anyway, I'm happy to talk to you all about arbitration afterwards, but I better let Henry talk because he pays the bills. So thank you all.